Good evening, friends. And as we had said that we will continue with the service law series, and to understand that service law, we thought there couldn't be a better person who can make things simple, subtle, and understandable. And the only one voice which came across was that you can dispense anything, but you can't dispense with the knowledge sharing, what Mr. P.S. Rajagopal shares. And as we say that we also held an inquiry as to there could be any other person who can share the knowledge in the right way and the right manner. We ultimately saw that everyone pinpointed that Mr. P.S. Rajagopal is the right person who can make you understand that which are the ways where you can dispense with the inquiry. But here is a case where you can even dispense with a person and with and without holding inquiry, but ultimately the net result would be that it should be only P.S. Rajagopal who can make you understand the service law in the best service manner it could be. And Beyond Law series, along with Trivikram and Associates, are too happy that Mr. Rajagopal, despite his busy schedule, has always been willing to share his knowledge with us. And that's they say that the difference between the ordinary and an extraordinary person is that little extra. That extra effort which Mr. P.S. Rajagopal puts in to share his knowledge is always fascinating. I will ask Mr. Trivikram to just give a brief intro. Being a weekend, everybody wants to listen to Mr. Rajagopal, and then they want to dispense with the legal system and go for the party, etc. Over to you, Trivikram.
Good evening, sir. Good evening, one and all. Mr. Vikas Chatrat has rightly mentioned that the senior advocate who is with us is an extraordinary, eminent person. No doubt about it. I would endorse it completely. And we are such a privileged crowd to be with the senior advocate on this evening. Not wasting much time. Over to you, sir. Once again, on behalf of Beyond Law CLC and on my personal behalf, a very warm welcome to you, sir. And over to you.
Good evening, friends. Vikas and Trivikram, and my dear friends. The question of dispensing with inquiry under the constitutional mandate, as also under the contract, would be a concept that would be better explained if we first understand why the inquiry is necessary at all. Because only if inquiry is necessary, the question of dispensing with it and circumstances under which it can be dispensed with, these questions would arise. Let me preface saying that the concept of dispensing with inquiry is something that we find in Article 311 of the Constitution of India. It is also the provision in the Constitution which gives a right to the civil servant to have an inquiry conducted in law, in accordance with law, before his services are dispensed with. Then the first concept we have to understand is whether the provisions of Article 311 or the principles underlying Article 311 is applicable only to civil servants, that is, persons who are servants of the state directly, or to anyone who is not a civil servant also, but happens to be a servant of an instrumentality of the state. I cannot help recalling the two judgments of the Supreme Court which gave a semblance of right similar to the one envisaged under Article 311 to the employees of the instrumentalities of state also. First was Constitutional Bench in Sukhdev Singh, where the Supreme Court considered the staff regulations made by the LIC, ONGC, and one another public sector organization, a statutory body, and held that these regulations which are made, they equally bind the corporations which have made them. Subsequently, it fell to Lord Justice Chinnappareddy, whom I would consider as doyen who extended the constitutional rights to those who were till then not covered by it, by saying in UP Warehousing Corporation's case that he does not see any reason why the principles underlying Article 311, which are nothing but what is already contained in Articles 14, 16, 19(1)(g) and 21 to servants of the state corporations also. That is a direct statement made by the Supreme Court, which put at rest all doubts whether the principles underlying Article 311 are applicable to servants of the instrumentalities of the state also. Thereafter, we have made a long march, and as of today, the settled position in law is that though Article 311 by itself is not applicable to the employees of instrumentalities of the state, nonetheless, principles underlying them would definitely be applicable to all public servants, or to put it precisely, all servants of statutory corporations and instrumentalities of state. First part of Article 311, it lays down, no person who is a member of a civil service of the Union or an All India service or a civil servant of a state or holds a civil post under the Union or a state shall be dismissed or removed by an authority subordinate to that to which he appointed. This clause, all that it says is a dismissal or removal from service can occur only from the hands of authority which appointed that civil servant, or the concept of appointing authority. We can say what we know very well today, that only appointing authority can dismiss or remove a or compulsorily retire a government servant. This part of 311, that is clause 1 of 311, is not very relevant for today's discussion, because we will be dealing with clause 2 and exceptions thereto provided by the provisos there. And let me clarify at the threshold. Clause 1 of Article 311 will not be applicable to persons who are employees of the instrumentalities of state. That is how this concept we come across and those of you who are dealing with criminal law, you would be well aware of this principle, that is, under Prevention of Corruption Act, sanction to prosecute need be given by authority competent to remove the public servant from office. In interpreting that protection under Section 19 of the Prevention of Corruption Act, courts have repeatedly held if he is a civil servant, appointing authority or an authority to which it is subordinate can only give sanction. But when it comes to servants of the instrumentalities of the state, where the concept of clause 1 of Article 311 does not apply, it need not be the appointing authority, but it should be the authority who is competent to remove or dismiss him from service. It is clause 2 of Article 311 which lays down the legal principle that no such person means no member of a civil service of the union or an All India service or a civil service of the state or who holds a civil post. No such person shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charge against him and given a reasonable opportunity of being heard in respect of those charges. Those charges, the civil servant should have an opportunity, not as an empty formality, but a reasonable opportunity. What is reasonable opportunity is not the subject matter of the present day topic, but it would be necessary to know what is reasonable opportunity, at least in a nutshell. What is the reasonable opportunities? The employee must be told of charges against him. Then he must have, the employer should lead evidence in support of the charges. The civil servant who is facing the charges, he must be given an opportunity to test the veracity of the evidence produced by the employer state in support of the charges. And lastly, in addition to testing the veracity of the evidence produced in support of the charges, the civil servant should have an opportunity to lead evidence in his defense. This is sum and substance of reasonable opportunity. Subsequently, certain judicially evolved concepts also are there. That is duty to disclose, duty to give reasons. They are not relevant for the present purpose. Every public sector undertaking or every instrumentality of the state has framed their own regulations or rules. Even in respect of central civil services, I think there is Rule 11, Rule 19, that is Rule 14 in the matter of conduct of inquiry, and Rule 19 has an exception provided thereto. Then in every state civil service also, there are similar provisions. Then, if any inquiry is not held in accordance with those rules, which more or less cover substantively, or to put it firmly, which captures the soul of Article 311(2), if an inquiry is not held in accordance with those rules, then the penalty cannot be sustained. Then there are two provisos which are relevant for present purpose. The two provisos are part of second proviso clauses A, B, and C. Now, under three circumstances, second proviso would be attracted, whereby the inquiry can be dismissed. First is clause A of proviso 2, that is, where a person is dismissed or removed or reduced in rank on the ground of conduct which has led to his conviction in a criminal case. That is the first circumstance under which an inquiry can be dispensed with. The rationale behind this proviso is not difficult to understand. So suppose a government employee or any public servant, he has faced a criminal prosecution, maybe under Prevention of Corruption Act, or even maybe under provisions of IPC, or any other penal law. If the employer wants to proceed on the basis of conduct which has led to his conviction, that is, there must be a conviction, and though your service rules do not contemplate the provisions of IPC as such, there are do's and don'ts in the service rules which would characterize those conducts as misconducts. For example, let us take a case of a civil servant being caught red-handed while accepting a bribe. It would be misconduct under Rule 3 of the conduct rules all over the country and all over in most of these service rules. Let us say a person is practicing bigamy. Now that is also a misconduct under the conduct rules. Then there may be, it may not be stricto sensu falling under any other conduct, any other clauses, but it may be a conduct which could be said to be a conduct unbecoming of a civil servant, or a conduct unbecoming of a public servant. Then where a person has amassed wealth, which is an offense disproportionate to his known sources of income. It is not difficult to say that all these are misconducts. Therefore, when a person is to be acted upon departmentally on the basis of a conduct which has led to his conviction, then inquiry is not necessary. It can be dispensed. It is dispensed with without anything more. Why this? After all, in departmental inquiry, the standard of proof is proof occurred in a preponderance of probability. But in a criminal case, proof required is proof beyond reasonable doubt. In a case where public servant is convicted, on the test of preponderance, the proof beyond reasonable doubt, it would be preposterous to insist that yes, as in criminal court he has been convicted, but still an inquiry has to be held by the employer, because it would be a luxury and if I may say so, it would be a Victorian luxury which would involve not only expense and waste of public time, but ultimately it would be a wasteful expenditure of both time and money. That apart, in a society governed by rule of law, judgments rendered by competent courts have to be respected and have to be accepted. On these twin principles, the first clause, that is subclause A of Article 311(2), nobody can question or doubt the efficacy of. Now there are two more clauses, clause B and C, clauses B and C, which could be debated. They are debatable. Clause B is where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded in writing, it is not reasonably practicable to hold such inquiry. That is, the second circumstance in which inquiry can be dispensed with is, it is not practicably reasonable to hold an inquiry. This and clause C, both of them were challenged. And Supreme Court in Tulsiram Patel upheld both these clauses, and it also upheld 42nd Amendment to the Constitution, which dispensed with right to be heard on proposed penalty. Now, coming to clause B, that is, where the authority competent to dismiss comes to a conclusion that it is not reasonably practicable to hold them. This arises in as simple a case as unauthorized absence. Of course, not too long ago, we had a situation, particularly in the Department of Health Services in all the states. Doctors would simply remain absent. They go to Middle East or any other more profitable country where they get better salary. They will never return to the work. Notices are issued to them, recalling them, saying that it is necessary for in the interest of work, you have to come back. Those notices can never be served on that doctor because he will not be in India. We will be sending him notices in India. Then we publish notices in the newspaper. In such a situation, it would be luxurious exuberance to have an ex parte. Then there may be a case where a civil servant may be simply absconding. These are cases which make the inquiry impractical. Then there could be other cases also. For example, let us take a case where we initiate the inquiry, or the employer initiates the inquiry. The inquiry is halfway through. Then it is found that witnesses have been purchased. And in such an event, holding an inquiry would be futile. Then there may be cases where, for example, take the case of a large-scale nationwide strike where action is to be taken against the strike leaders. There are definite materials available to the government to assess the activities of particular, what should I say, gang leaders, though it is a very bad phrase, a coterie who are propping up this type of activities. And if it may be quite possible to hold the inquiry also, but then immediate action is required to prevent greater damage to public interest. Then there may be cases and cases where the employer comes to know, let us say in a particular case, after issuing of the charge sheet, he comes to know that the witnesses are being threatened with dire consequences. There is a threat addressed to them that, look, if you come and depose against me in the inquiry, I will kill you. Or I would get you knocked out of the scene. Several such instances can develop. We cannot imagine what situations may develop in any particular case. Therefore, when the employer comes to a bona fide conclusion, it should not be a pretense. It should not be, suppose an employee like me has spoken in some meetings or has even issued handbills making certain allegations against the employer, saying that the employer is maybe a state, maybe a public undertaking, whatever it is. He is practicing discriminatory measures where for the same conduct, it is treated as a misconduct and one set of employees are punished. For identical conduct, no action is taken against them. And perhaps some of them may get promoted also to selection force. In such a case, what happens? Holding of inquiry may be embarrassing to the employer. That is, it is quite possible certain unpalatable truths might come out in the inquiry. Therefore, the courts have said that mere embarrassment to the employer cannot be said to be a reason to say that it is not practicably reasonable to hold the inquiry. It is not practicable to hold the inquiry, or it is not reasonably practicable to hold it. Another test that is laid down is the situation which renders that it is not reasonably practicable to hold an inquiry need not be existing on the day you issue the charge memo. Such a situation can develop any stage during the inquiry. In such cases also, it would be permissible for the employer to dispense with the inquiry from the stage at which such reasonable impracticability of holding the inquiry has arisen. This is a case where, in fact, in Supreme Court, while upholding clauses B and C, I will tell what is the exact provision of clause C is, where the president or the governor, as the case may be, is satisfied that in the interest of the security of state, it is not expedient to hold such a. This normally arises when a civil servant is acted against for spying activities or from leaking certain interests of security of state, the information of security of state. Several such possibilities are. Therefore, clause B and C. Clause B envisages dispensation of inquiry when the dismissing authority comes to a conclusion that it is not reasonably practicable to hold it. Clause C envisages a situation where it is not expedient. Look at the words used. Clause B is reasonable impracticability of holding inquiry. Clause C is inexpediency of holding the inquiry. Inexpediency is situation is very peaceful. No witness is threatened. Everything is moving like calm Ganges. No turbulence. But still, if something comes, if the charge is proved, certain things will have to come on record. The charge has to be put. Those things coming out on record may threaten the security of the state. Of course, when we say security of state, I am not referring to the present day securities of sealed cover states, where they give press freedom is curtailed, your permission to telecast is suspended. Then, when that action is questioned, a sealed cover is passed on to the court, saying that if you give reasons, it will amount to threatening the security of the state. Not such make-believe inexpediency. It must be a genuine interest of the state or security of the state that would be security of the state, not even interest of the state. A genuine threat to a genuine apprehension, a genuine cause to say that it is not expedient to hold the inquiry. Now, there are certain principles which have been evolved over a period of time. Certain employees of law in Satyavir Singh, they were proceeded with on the ground that on the ground that they were proceeded and the employer came to conclude that it is not practicable to hold the inquiry. Of course, the employees were of research and analysis wing. But that itself was not sufficient to hold that it is not reasonably practicable to hold the inquiry. What happened was that the material witnesses who were co-employees of the accused, they would be intimidated not to tender evidence in the inquiry. It was a case where Even if intimidation was not possible, no employee would generally come forward to tender evidence in support of the charges because it was pursuant to a charter of demands of that particular association. There, Supreme Court approved dispensation of employee. Then in Ajay Manchanda, which emanated from Chandigarh, the dispensation of inquiry on the ground that it is not reasonably practicable to hold the inquiry, it was upheld on the basis of affidavits which said there were sufficient indications that the witness was being pressurized and compelled to withdraw his statement given during the period of investigation. This dispensation of inquiry under clause B and clause C, though Tulsiram Patel is a very elaborate judgment, ultimately the principle underlying the judgment is that while security of tenure is necessary to have a fearless civil service, it is also necessary to bear in mind that interpretation of any law or the basis for any law should be largest good to the largest segment of the society or largest number of people. No doubt, holding an inquiry in terms of principal part of Article 311(2) is non-negotiable concept of security of tenure. But security of nation, which is governed by clause C of the proviso, is larger than security of tenure of its concern. Similarly, if the inquiry is, if as we understand, the object of inquiry is to discern the truth, and situations are such that the very object of discerning the truth by holding an inquiry is most likely to be defeated, then it can be said that it is reasonably not practicable to hold an inquiry. But at the same time, in Tulsiram Patel, it was also stated by the Supreme Court that the important aspect of why this security of tenure is required has to be borne in. And at the same, it should also be borne in mind that these provisos are exceptions to the principal part of Article 311. And dispensation of inquiry should not be used as a tool to dismiss or remove a civil servant where the management feels that, or where the government feels that it has no case to prove against the government servant. See, these are all very high sounding principles. Article 311(2), proviso clause B, which says that you need not hold an inquiry, or inquiry can be dispensed with where it is not reasonably practicable to hold an inquiry, is no doubt a very high sounding principle evolved in public interest. But there should also be a safeguard. That safeguard is the government cannot invoke this clause of reasonable impracticability to overcome a situation where it has no case to prove against the government servant, or where it has no evidence to prove the charge against the government servant, or to put it differently, where the government wants to show on record that there are grave charges as a tool to remove him from service by resort to clause B, saying that it is not reasonably practicable to hold him. Though these two provisions say that whether it is reasonably practicable to hold the inquiry or not, the decision of the dismissing authority is final. The courts have held that the stated finality in the rule would only open the doors for judicial review. That is, notwithstanding the finality attached to it under the rule, a constitutional court under Article 226 has jurisdiction to test the validity of dispensation of the inquiry with reference to requirements of clause B and clause C. Then there is one aspect of the matter where the judicial opinion is divided, and the very nature of things, it has to be divided. For example, some judgments have said that the reasons why it is not practicable to hold the inquiry is to be stated in the order of punishment itself. That is, the disciplinary authority has to say in his order dismissing the employee, it is not reasonably practical to hold the inquiry for 1, 2, 3, 4 reasons. And then employee will have an opportunity to question those reasons in a writ court. Then there are also judgments which have approved the cases of dispensation of inquiry, which did not give any reason why the inquiry is impracticable to be held, on the ground that the reasons are such that their very disclosure would have endangered somebody or the other. Like in a case where witness is threatened, and on that reason the inquiry is dispensed with. It may not be practicable to insist on reasons in the order of dismissal itself. Maybe it may come as a affidavit before the court, where the employer will be required to explain the reasons on the basis of which the inquiry was dispensed. Now, as in law, administrative law, there is always a difference between not necessary to convey the reasons and the concept that, and the other extreme of saying not containing reasons at all. That is, the difference between, in some service rules, without assigning any reason, this contract can be cancelled. Or without assigning any reasons, your services may be dispensed with. Even in such cases, it is necessary that the file should contain the reasons. And those reasons will be tested by the Constitutional Court on the anvil of the wording of Article 311, Proviso B to Clause 2, and Proviso 3 to Clause 2, whether on the reasons stated in the affidavit, it is justified, whether the employer was justified in holding that it is not reasonably practicable to hold it, or whether disclosure or the holding of the inquiry was opposed to interest of the security of the state. Therefore, in larger public good, these exceptions are envisaged. At the same time, these exceptions cannot be invoked as a cloak to cover up an act of victimization or an act of no evidence against the employee. Because, as we have seen, the essence of public service, if you want a productive, honest, efficient public service, which obeys the law and not the minister, there must be security of tenure. And security of tenure, in fact, earlier the service rules used to contain a clause that any employee can be services of, if any employee can be dispensed with 3 months notice or 3 months pay in lieu of notice. Those were held to be unconstitutional in Central Inland Water Transport case by Justice D.P. Madhav. And by majority judgment of the Constitution Bench in DT3 Mazdoor Congress case. In both those judgments, why the security of tenure for public servants is necessary in public interest and also in the interest of the employee have been explained by the Supreme Court in great detail. Therefore, these clauses B and C of the proviso to Article 311(2) will have to be understood in their proper perspective to be invoked only in rarest of rare cases, which answer the phrase reasonably not practicable to hold the employee or not expedient to hold the employee in the interest of security of state. In fact, at the point of time when we all entered when my generation entered the profession, and we were talking about the glory of security of state and absence of policy of hire and fire in state services and public sector services. When judgment of the Constitution Bench in Tulsiram Patel came, upholding these two provisions, initially we were taken aback how the Supreme Court could have upheld these provisions. These provisions are not new. They were there originally in some form, thereafter by 15th Constitutional Amendment in a modified form. Only thing that triggered reference to Constitution Bench in Tulsiram Patel was by 42nd Amendment, right to be heard on proposed penalty was taken. And there was a judgment rendered by 3 judges bench in T.R. Challappa, which had taken a view that even on conviction, if a person has to be punished without holding an inquiry, some amount of say has to be given to the employee on the materials that led to conviction, or an opportunity should be given to an employee to say that in the facts and circumstances of the case, the conviction was not justified. Then there was another judgment which in I.M. law, which had said that Article 310, which says that every civil servant holds his office in as long as pleasure of president or governor is existing. That is, every civil servant shall hold office subject to pleasure of the president or governor. Then that to remove all these confusions, of course, on IM law there was never any doubt. Subsequently, in BP Singhal, that is about the removal of the governors. This concept has again been discussed. Though governor is not a public servant, he is not an employee of the state government, he is not an employee of the central government. Governors were being removed at every change of the central government. Then the Supreme Court said that he may not be entitled to be put on, he may not be entitled for disclosure of reasons, but you cannot recall or remove a governor without there being reasons. In fact, the seed of exceptions to doctrine of pleasure and how clauses B and C are justified, the Tulsiram Patel is the answer. It is one of the glorious judgments rendered by Justice D.P. Madan, one of the great constitutional judges, who in fact wrote the Brajanath Ganguly case judgment also. And now, power to dispense with inquiry in the circumstances set out under clause B and clause C of proviso below Article 311(2) is unquestionable. But at the same time, the exercise of that power is available for judicial review. And in judicial review exercise, if the court comes to a conclusion that there were no circumstances to hold that it was not reasonably practicable to hold them, or if the court comes to the conclusion that it was not inexpedient to hold the inquiry for the reasons of security of state, then those orders of penalty can be successfully challenged. And one important aspect is these clauses can be invoked only where the misconduct is of a nature which would involve imposition of punishments referred to in those two respective clauses, namely dismissal, removal from service, or reduction in rank. For so any lesser penalty, inquiry cannot be dispensed, because if the penalty is supposed to stoppage of income, that means charge is not as grave as involving security of state or reasonably impracticable to hold the inquiry. Therefore, in such cases, penalties less than reduction in rank, this type of the exercises to dispense with the inquiry would not be permissible. Thank you very much. It is a this dispensing with inquiry being an exception to the rule, it is difficult to understand the exceptions. General rule, we are so much used to say that security of tenure, the exceptions are always very limited, and it would arise in very few cases, very few cases. Therefore, as advocates, we would find it difficult to understand the nonsense of these concepts. But I think Tulsiram Patel gives a lucid explanation of all these aspects. Therefore, I can only say in conclusion, please read Tulsiram Patel. It would give you a broad idea, because I would use again the word broad, because practical situations can never be predicated before the act. Thank you very much. Thank you, Vikas, and thank you, Trivikram.
Thank you, sir. So one question which normally arises is, I have seen that we say that conduct leading to the conviction has to be seen. Even that Tulsiram Patel 85 Supreme Court and 86, the citations may vary. It says, now there's a lot of debate as to how will you conclude that conduct leading to the conviction has to be seen, number one. And number two, they say that in certain cases you have to hold an inquiry as to see as to what the conduct is. That is meaning thereby you have to read that judgment. But in some cases, normally it is just like in Prevention of Corruption Act. They normally say that your conduct is of a moral turpitude, you stand convicted, you need not see what the conduct led to the conviction. Therefore, your services can be dispensed away straight away, invoking Article 311 or whatever the service regulations are. So what would be your view on this particular aspect?
View on moral turpitude or view on conviction?
I'm both, because they say conduct leading to the conviction.
Conduct leading to means there can be cases where there can be conviction, but the allegation itself may not be one involving moral turpitude. But in case of allegations under Prevention of Corruption Act, it would require great insensitivity to morals to say that conviction does not involve moral turpitude. Yes, as Advocate Vikas is right. We have argued and we continue to argue that even taking a bribe does not involve moral turpitude. Because in this case, I was framed. But it is difficult to say that reasonably, and when we are not appearing for the accused, and we are not exposing the cause of the accused, to say that conviction under Prevention of Corruption Act does not involve moral turpitude. It is impossible to say. But at the same time, take the case of conviction under Negotiable Instruments Act, a check bounce case. Every conviction may not involve moral turpitude there. Nonetheless, conduct leading to conviction for check bouncing case is also a misconduct, because most of the service rules contain a clause that the employee shall conduct himself, shall manage his affairs in such a manner that he is not unduly indebted. This clause is there. What is the meaning of unduly indebted? That is a clause which lends itself to circumstantial interpretations. But whatever may be the circumstantial interpretation, it cannot be said that a person has managed his finances so badly that he doesn't have balance in the bank account to meet the check he has issued. It is difficult to say that it does not invite an action. It does not invite an action. Therefore, in certain circumstances, punishment for breach of Section 138 in the Judicial Instrument Act, it is possible to interpret that the conduct leading to conviction did not attract moral turpitude. It is possible to say. At the same time, in a given case, it is possible to come to a conclusion that, look, this man is in the habit of issuing checks only to cheat the people. Then the conviction under Negotiable Instrument Act would also be one attracting moral term. Therefore, it is a value judgment to be taken on the basis of facts and circumstances of each case of conviction to say whether it is of such a magnitude or involved moral conviction, moral turpitude that it attracts dismissal, removal, or reduction in rank. That is the reason clause B, where this dispensation with inquiry is there, the clause 1, that is clause A, dispensation of inquiry for conduct leading to conviction. Hearing on proposed penalty is still there. You can point out to the employer that there is, yes, there is a conviction. It is true, but it does not attract the penalty of dismissal or removal or reduction. It is permissible. Or as said in Tulsiram Patel, even where at the time of imposition of penalty you are not given an opportunity to be heard on the proposed penalty, appeal against the punishment is a stage at which you can point out the disproportionate nature of the punishment. It is also permissible. Then about what Mr. Vikas said about the conviction. Where conviction itself is suspended by the appellate court. For example, in criminal law, appellate court has got power to suspend the sentence, which they normally do, and it also has got power to suspend the conviction itself, where conviction itself would be a disqualifying factor. Of course, this concept was first stated with the Supreme Court in Narang versus Narang, where the case of director of a company. On conviction, he has to vacate office. There is no choice. In such cases, appellate court, if it is satisfied with the facts and circumstances of the case, it can suspend the conviction. Then there is a provision under the Banking Regulation Act that no banking company shall employ or continue to employ a person who has been convicted. Therefore, a bank employee who has been convicted without anything more is disqualified for holding employment in the bank. In such cases, perhaps the appellate court can invoke the power to suspend the conviction itself. These days we are seeing to overcome the electoral disqualifications. Normally, the appellate court stays the conviction. And there are cases where the convictions are not stayed also, even in such cases. Therefore, there may be conviction, whether it involves moral turpitude or not, is a question that has to be decided on a case-to-case basis. But every conviction would not result in a punishment. One Haryana case where for a petty offense, which was compounded or not compounded, whatever it is the case, you cannot invoke this provision. And question in all these cases that would arise is whether it involves moral turpitude. That is a matter which can be agitated with the court. Second aspect is, suppose a person convicted by the trial court he is acquitted in appeal, or maybe in special jurisdiction. What happens? Then, of course, he will be entitled to seek reinstatement. And the treatment of the period during which he suffered unemployment because of the order of conviction, it is a matter again to be settled on a case-to-case basis. Though in Reserve Bank of India's case, Supreme Court has said he disabled himself from being employed, therefore no question of back wages. It is a gray area. I think it would depend, the molding of the relief would depend upon case-to-case basis. Have I answered substantially your question? Because
But what you said on reinstatement, the back wages, though there's latest judgment also 2020 Rajnarayan, which say you will not be entitled for the back wages. But there are certain statutory rules which provide that upon reinstatement, upon acquittal, then you will be entitled for back wages. Certain rules provide that the employer will decide. I think that particularly rules will apply, and what we say in law, that judgments are not statutes. You
yeah,
have to
the
interpret
rule,
as per statute.
rule position, rule, if rule gives you the right, you can take the right. But my experience is that most of those rules, they deal with back wages or suspension in cases of departmental inquiries, not in cases of conviction. Now, take a case where a person is taken into custody. There is a deemed suspension provision in the service rules where the period of custody exceeds 48 hours. By interpretation, courts have held that deemed suspension is only for the purpose of regulating his salary for that period. Since he would have disabled from attending the office, that period will have to be treated as not on duty, or he is under deemed suspension. But there are some cases where the courts have held the moment he is released, enlarged on bail, if it is a case of deemed suspension, the suspension should be revoked. There are several aspects to this. But on the question of back wages in cases where a person is removed on account of conviction, what should be the back wages on his acquittal in appeal? There is no rule governing the situation to my knowledge. If there is any rule, a very happy position for the employee. If there is no rule, then it should be a discretionary order to be made by the employer. And discretion means, like every discretion, it has to be exercised reasonably. Now, there was a case where a person was convicted as being a part of an unlawful assembly when he had gone to his native place on leave to attend a village fair or village annual jatra or annual festival in a temple there. In such case, on conviction, you cannot be, this clause B cannot be invoked. Therefore, like all other powers, the power to invoke clause regarding punishing without inquiry should also be tested on the anvil of proportionality, rationality, reasonableness in every case. Wording, power, existence of power is one thing. Exercise of it is altogether different thing.
The next question is, which normally we again take, like we have seen that you know the judgments off the cuff. So for a young lawyer or a lawyer, how will you tell that he should able to collate the judgments as to how it should correlate with the case law once he's with the case which he's preparing?
As I always say, Reading and assimilating the facts is the first thing. You should not rush to the law reporters. You should you can at best run to your dictionary when a client comes to you to understand each and every fact. On the facts, you have to formulate what is a possible solution in law. And accordingly, you have to mold your case. And I am not tired of telling that our problem today is too much emphasis on case law. Because what is happening is there is a such volume of case law generated and more than generation of case law, volumes and volumes reported, which we'll be reading almost every day. Because like we say that, pray to God at least for 5 minutes a day before you go to bed. Most of us have the habit of at least reading what is reported in law journals of that particular day, at least for that 10 to 15 minutes in the before we retire for the day. That 15 minutes reading of the law should not, or a law report, should not make us run to journals when a case comes. When a case comes, reading the brief, Renan Martin, and maybe Oxford or Chambers Dictionary. These should be our tools. After that, what is the law? Of course, while reading the file, as a matter of fact, we should read the corresponding provision of laws. Most of the time, interpretation of law will be based on plain language of the act or rule government. And there should be minimal need for us to rush to the library. This tendency to run to the library should be put on hold. I don't say it should be stopped. Put on hold till you understand the facts and provisions that govern the particular situation.
That's clear. I've just seen like Mr. Uday Hola and yourself time and again playing emphasis on Renan Martin. It is as if in the profession, if you have to take a leap like Wright brothers to fly, Renan Martin has also become an essential feature to be for becoming a good lawyer, so that you're able to understand the nuances of precis writing, making your submission in the right way, which are what we say in a funnel manner or in a structured manner, which can be understood in the right manner. And time and again, we have asked a lot of people, still we will also again, if you have to you have read the file at your place, and once you have to start your argument, what suggestion will you give to a young lawyer that how he should funnel his submissions?
I could not quite get your question, because can you repeat?
The opening statement before you start in the court, what is the best way to put forward? Because the judge will, they say the first impression is the last impression. So how to make the judge, I will not say grounded, but at least attached to your submissions at the right stance?
See, it is very often said that if you cannot make an impression on the court within your first 90 seconds, then it is difficult to make it at the admission stage. I have also read a statement made, if you cannot argue your case within 20 minutes, better go home and write a book. These are all only guidelines to guide us in the direction. But I don't think there is any set formula for your opening statement. Opening statement is imperfect. Each advocate has his own style of formulating the opening statement. What can be the opening statement is what I have been practicing. Formulate the strongest argument you have on that case. Normally, we might have raised several grounds. Grounds A to Z, then AA to ZZ, triple A to triple Z. But most of it you would not be arguing even in the final hearing of the writ petition. Ultimately, even in the final hearing of the writ petition, maximum, generally 2, maximum 5 points would be argued. You formulate strongest of those grounds on which you want to make your case. State the first 2 grounds in the first minute. What is this matter? My lords, he was an employee and then he has not been promoted. Start your statement like this. One of the members of the Departmental Promotion Committee was not qualified to be appointed or made a member of the Departmental Promotion Committee. Therefore, I am here. Or you say, for example, in the matter of promotion to IAS, you want an admission only at that stage because promotions are rarely stayed. You say this is contrary to Rule 5 of appointment to IAS by promotion rules. Inasmuch as I was within the age limit of 54 years as on the relevant date, but by a wrong interpretation of the rule, I have not been considered by the selection. Yes, you may have hundreds of grounds. Make that statement which indicates the violation of rule or provision. Ultimately, we can get relief only when we point out breach of rules. Point out the rule or rule book which is breached. Then it is possible in some cases, every rule would have been apparently followed, but substantially breached. As in the case of Badrinath, where Lordship Mr. Jagannath Rao said, what is consideration for promotion? In such cases, opening statement may be difficult, but in majority of the cases, it is possible to make an opening statement referring to the breach of rule. In other cases, yes, it is your what dialogue you write. Whether you have a Gujarat, whether who is your Gulzar writing dialogue for you, or whether what would be the dialogue you formulate. That is just it happens. I cannot say how it is made. Some things happen. Most of the things we prepare and make a statement. Sometimes that statement just comes out. That statement would come out. Though most of us say, luckily this statement came. Not luckily. That statement comes depending upon the extent of assimilation of facts that has occurred inside. You have to intern those facts. Then one sentence which will clinch will come out.
That's true. They say that the more you practice, the more you read the judgments, then automatically your vocabulary and content while presenting in the court improves. Because ultimately those words which we use, like in a law, somebody says, we have been failing to understand why do we say null and void, because the meaning continues to remain the same. So thank you, sir, for sharing your knowledge. It's always a pleasure connecting with you and your entire team. We are thankful to Mr. Jayant and Ashwini, who has been helping us to connect with you. And of course, we have a direct access to you. Thank you, everyone. Stay safe, stay blessed, and
Thank
have
you.
a happy weekend. Namaskar.
Thank you.